Okay, you can start now.
A very good evening to you, ladies and gentlemen. We warmly welcome you to the first episode of the webinar series held in English for the year 2024, organized by the Seminars Committee of the BASL on an interesting topic of applicability of Electronic Transactions Act number 19 of 2006. As you all know, this webinar series is conducted on the Zoom platform. However, for those who have been unable to register on Zoom, they could also join by watching the live stream on BASL YouTube channel. First of all, I would like to thank the Seminars Committee of the BASL, headed by Mr. Isuru Balapatamadi, Secretary to BASL. And I would like to take this opportunity to thank the President of BASL, Mr. Kaushal Navaratna President's Council, for the support and guidance given to us in organizing this webinar series. Today's topic, as I mentioned earlier, is applicability of Electronic Transaction Act number 19 of 2006. And we have two eminent legal professionals joining us today to share their knowledge with us. I now take this opportunity to introduce the resource person and the moderator for the day. Firstly, I would like to welcome Dr. Tusita Abesekara, attorney at law. His profile will now be shared on the screen. And the moderator for the day is Ms. Vardhani Karunaratna, attorney at law. Her profile will now be shared on the screen. So those are that's our resource person and the moderator for the day. So if you come across any questions or any points to clarify, please feel free to key it in on the chat box on Zoom, which will reach the moderator. And it can be directed to our resource person to answer and clarify your doubts. So now I will hand over the proceedings to the moderator. Over to you, Vardhani.
Hi, Kavishan. Thanks for a kind introduction and the support as host in this evening. Good evening to all of you. First of all, I must extend my sincere gratitude to the Bar Association, Mr. Kaushal Navaratna, President's Council, the President of the Bar Association, Isuru Balapatamadi, Secretary, as well as the Chairman of the Seminars Committee, who generously provide their support and assistance in organizing this webinar series for the benefit of the membership. And also, Dr. Tusita Abesekara, thank you for accepting our invitation and joining with us, sharing your valuable thoughts and insight. And also, we know how busy you are, but despite your busy schedule, still you were willing to stay tuned with us for hours time and also share your expertise just to enlighten members of the elite profession in Sri Lanka. So if I am to give an introduction to this today's session, as Kavishan indicated, this will be basically a kind of a discussion, and also the participants are invited to raise concerns, and there will be a Q&A session subsequent to this presentation and the discussion done by the panelists. So please stay tuned and also engage in active conversation and dialogues for the benefit of the audience. So if I am to give you a bit of a background to this today's session, we all know during the pre-evolved arena of electronic evidence, evidence generated through electronic devices, not even accepted within the legal realm of evidence law. If you look at the case law decided in 1970s, 1980s, not even there's no evidential value even given for any such thing generated through electronic modes. But we know subsequently with the Evidence Special Provisions Act number 14 of 1995, the provisions are given in law to introduce this evidence in electronic form, provided that the relevant stipulations set out in the Act is met with. But still, the application was somewhat confined only to admissibility of electronic documents, evidence in an electronic form only. But with the introduction of Electronic Transaction Act number 19 of 2006, which is based on UNCITRAL model on electronic commerce, as well as UN Convention on Electronic Communications and International Contracts, we all know we are now in par with the international standards, norms, and principles applicable to electronic contracts as well as electronic transactions. So if you look at basically the preamble as well as the section 2 of this act, I think we don't need to spend too much of time to see why we want to have separate piece of law to deal with electronic transactions in Sri Lanka. And also, I believe many of the participants are well conversant with these type of things, maybe in your undergrad or maybe as your postgrad or perhaps in your practice as a commercial or civil practitioner. But still, I would say there are many, many gray areas in applying these provisions clearly given in the Electronic Transaction Act in a practical context in court proceedings. I must say, lawyers should also be a little responsible, because we have noticed in many occasions this lack of knowledge and understanding of the applicability of these relevant legal provisions only made them impossible to get these provisions applied effectively in court proceedings. We complain there are no many authorities decided on these things. It's simply because nobody, maybe rather I must say only few lawyers are trying to get their litigation using these provisions given in the Electronic Transactions Act. So I think that is the very reason. I know there have been many series of discussions organized by BSL and some other organs regarding the same topic, but still we thought it's worthwhile and it's a timely effort to bring the attention of our members about the salient features of the Electronic Transaction Act, especially given the context, but we are all aware the new amendment done to the Civil Procedure Code, Act number 29 of 2023, provides provision about how to tender the electronic evidence, basically replacing the Evidence Special Provisions Act. So there might be a bit of a confusion or misconception how it impacts Electronic Transactions Act as well. So I'm sure Dr. Abeysekera would also made it very clear the application and the key principles norms applied in this Electronic Transactions Act. So as we mentioned, if we quickly look at the objectives of this act, it clearly says it is simply to facilitate domestic and international commerce and eliminating legal barriers and establishing legal certainty. So now we all live in a global village, and it is an attempt to recognize and enforcement of electronic transactions. And also it plays an important role in fitting online contracts with classical rules of contract. Because end of the day, whether it is in electronic form or not, most of the matters will be agitated within the form of contract or maybe a violation of contract or within such context. So therefore, this is separate laws and criteria guidelines given as to how these electronic transactions be applied and what limitations and the scope of this act. So I would then invite Dr. Tusita Besekara to enlighten you on, especially to give a start on the recognition for electronic records in Sri Lankan legal context under this Electronic Transaction Act.
Okay. Thank you, Ms. Vardhani and Mr. Kavishan for your lovely introduction on the theme and the discussion. Very good evening, ladies and gentlemen. Today, we are going to basically discuss about the applicability of Electronic Transaction Act. As Ms. Vardhani correctly mentioned, there are some doubts on that, especially in the form of application of evidence, electronic evidence. However, all of these points start with the electronic era. As you all are well aware, as you all are experiencing, we all are living in an electronic era. And this act addresses the electronic nature and electronic commerce. And it is a part of the act's objectives. So my presentation initially addressed these parts, especially the introduction to the e-commerce. Why I want to discuss this one? E-commerce is one of the major objectives of this act. Without having a proper identification or understanding on the e-commerce, I personally believe we cannot understand the provision wording words in this act. So we should have some sort of basic knowledge on e-commerce, the parameters, four corners of the e-commerce and electronic nature or electronic sphere. Then after that, I will show you the place where we can locate the Electronic Transaction Act in ICT legal regime in Sri Lanka. Then after that, I want to discuss with you the formation of electronic contract. Of course, electronic contract is the heart of the e-commerce. Any type of commerce, basically, based on contracts. Electronic commerce based on contract. Even though the word e-commerce in here, it does not necessarily mean that it's only applicable to commercial sphere. Right? When and where necessary, electronic nature is there, electronic contracts is there, we can easily apply Electronic Transaction Act. And it is the one of the objectives of the act. And it was tied up with the recent amendment to the act, which is named as Electronic Transaction Act Amendment number 25 of 2017. After all, I want to discuss with you the general nature of e-contract, offer and advertisement on web, the difference between these two terms. We know the difference of offer and advertisement on invitation to treat, but in electronic nature, we do have a separate perspective on the same, right? Electronic communications and competent parties of the contract. Normally, we do know that the parties to the contract, basically two. But in electronic nature, we do have separate parties. In some cases, people think the computer is also a party of it. So we can iron out those kind of things in electronic nature. Especially with special attention to the postal rule in common law. Actually, we cannot apply the postal rule as it is in common law to the email or any other electronic communications, right? Electronic address. We should identify the electronic address in the process of identification of acceptance. And online contracts and free contract. In electronic nature, we cannot say electronic and online contracts are contracts, right? Actually, they are not contract in a sense because there are no such a consistent diagram. And we should identify the excluded form of contract on Electronic Transaction Act. And say what excluded from Electronic Transaction Act and what are the rules governing evidence. As Ms. Vardhani correctly pointed out, it is a kind of conundrum in application of Electronic Transaction Act. So finally, I want to discuss with you the electronic signature. As a part of it, I want to discuss with you the digital signature. Keep in mind, all digital signatures are not electronic, but all electronic signatures are not digital. The digital signature is a part of electronic signature. Electronic signature is a very broad term. So this is my lineup. And first of all, as I said earlier, we should identify what the electronic commerce. Electronic commerce is a commercial commodity, a commercial concept, simply addressing buying and selling of goods and services, or both of them. Not only that, this concept addresses the transmitting of funds or data over an electronic network, possibly primarily in the internet or any other type of communication channel. So these type of business transaction occurs either business to business, this concept connect two businesses, or business to customer, this is what is more popular. Singer sells something to their customer, buyer bonds, so they directly address their customer, business to customer. Most interesting point in here, consumer to consumer. Thanks to the operation of electronic commerce and platform, this concept connect consumer. Actually, it is an advantage and benefit on customer side. So customer can read out and examine, inquire into the previous customers' comments. When you place a book, when you place an order or book a place through, for example, booking.com, you can read out the previous customers' comment. So it is a benefit on electronic commerce, consumer to consumer. This concept connects consumer to consumer, or finally, consumer to business. Of course, it is back office, after sales services. Not only that, this concept addresses different perspectives in commerce, such as mobile commerce, electronic fund transfer, supply chain management, electronic data interchange, EDI, online transaction processing, inventory management system. The managers and authorities, they can easily control entire process thanks to the electronic commerce and install computer system. And it automatically collect data. It is another vulnerable area. If you send a message, a WhatsApp message to the pharmacy nearby you, if you send your prescription, it automatically creates different data. Some of them are highly concerned the privacy issues, right? So this concept, electronic commerce, addresses different aspects in day-to-day life. And you should know the scope of e-commerce. At the layman mind, e-commerce is a kind of online sale, but it is not. It also covers a range of different aspects in commerce, such as preparation of estimates online, advertising, provisions of an electronic catalog, consulting of users, access plan to point of sale, online payment, delivery tracking. In this process, the customer as well as the seller, they can track down entire process. They can check where is it. And real-time management, easily they can manage the stock. Especially in AI support, without any human involvement, the system can control entire system, entire product availability. and finally after-sales services. So the e-commerce scope is a very broad concept, and e-commerce addresses different perspectives in commercial sphere. A part of it, the online store is a part of it. So online store consists with online electronic catalogs, search engines, virtual caddy, payment system, order tracking, and back office. Heart of all of them is virtual caddy. In legal sense, that is the heart. That is the place we should address in first, we should address in legal concern, virtual caddy. So now you can identify the electronic store consists with different parts, and virtual caddy plays a vital role in this process. Still, we are in the very beginning of the discussion. Actually, I'm in the middle of the introductory remarks. I'm providing a basic picture of e-commerce. This is the Sri Lankan ICT legal regime. The Sri Lankan ICT legal regime consists with different statutory instruments such as Intellectual Property Act, Electronic Transaction Act, Payment Devices Fraud Act. Most popular act in this field is Computer Crime Act. There are a lot of incidents. Information and Communication Technology Act, which mandate the e-policy or electronic policy, internet policy, e-governance in Sri Lanka. Payment and Settlement System Act, Evidence Special Provision Act, which discussed the admissibility of the electronic evidence in Sri Lanka first time. And interconnection rules under the Sri Lanka Telecommunication Act, which govern the service providers situation. Right to Information Act, not exactly act in the ICT field, but we can use it. And finally, Personal Data Protection Act. However, this is not the last one. There are a lot of acts yet to come in the pipeline. You know that universities Online Security Act. So these are the points in ICT legal regime in Sri Lanka. Heart of everything in here is Electronic Transaction Act, as it addresses the contracts in electronic nature. In day-to-day life, as you all are well aware, all transaction involves with contract. All transactions involve with contract. In electronic nature, it is electronic contract. Electronic contracts entirely governed through, in Sri Lanka, Electronic Transaction Act No.19 of 2006. So we can say Electronic Transaction Act is the heart of the all ICT legal regime in Sri Lanka. Even though
So
it is the heart.
if I interrupt
Yeah,
you for
sure.
a moment for Dr.
Yeah,
Abhisek.
sure.
We know the section 11 deals with the electronic contract, the formation of acceptance and offer. So does
Yes.
that mean anything other than the electronic transactions or electronic contracts are not valid, or is there any issue with the enforceability of such contracts in this sphere?
Actually, if the contract is in electronic nature, it is governed through Electronic Transaction Act. Throughout the wordings of Act, throughout the salient features of the Act, you might have seen a word unless otherwise agreed by the parties. So still in Sri Lankan nature, the parties can decide the nature of the contract.
Yeah, simply even if any contract is not in electronic form, does not debar partying in proceeding with their rights and obligations, because that has been expressly recognized under Section 11 in par with the ancestral rules of functional equivalence.
Yes.
So basically, they identify, while having these provisions on electronic contracts governed under the Electronic Transaction Act, it does recognize the other contracts outside the ambit of Electronic Transactions Act as well in operation, and giving value to that in a legal context. Is that correct to say that?
Yes. And parties can decide the nature of the contract. They might have some of them in electronic. For example, they start the process with electronic nature, made initial offer or invitation to treat in electronic mode, but still parties want to make a normal contract outside of the electronic contract. So that is there. That freedom is there. As you all are well aware, as a lawyer, the heart of contract is freedom, the freedom of contract. Both parties, they can enjoy the freedom. That is the heart. That is the heart of any type of contract. Freedom. As far as they enjoy that freedom, they can come into the point of agreement. Based on the agreement, they create the contract. So still parties can decide as a part of their freedom of contract, the mode of the contract. Even though they have used different electronic versions in the process of making contract, right? And for the security of the contract, still parties can decide not to go to the electronic version, right? So that freedom is there. That's why I told you, time to time, when and where necessary, this act use the term unless otherwise agreed by the parties. So still parties can decide their mode, right? So these are the parts of the ICT legal regime. This is what Vardhani correctly mentioned in here. To respect these type of international obligation and to respect the nature and chemistry of the world, we adopted and we adhere into the electronic laws. Especially the Sri Lanka is a signatory to UN Convention on the Use of Electronic Communication in International Contract, ECC, which was ratified on 7th of July 2015 and entered into the force 1st of February 2016. As a result of the same, we change some parts of our Electronic Transaction Act. The earliest version of Electronic Transaction Act, number 19 of 2006. That's why we introduced, the Sri Lankan government introduced the Electronic Transaction Amendment Act in 2017 under the number 25, right? So that is the international influence behind the act. First of all, it would be better to identify the terms in the act. Electronic Transaction Act. As an academic, I believe that entire process in courts, or even more correctly law, is a game of word or word of game. We are work around the words. We are play around the words. Actually, we are working around the interpretation of words. In this process, the purpose of act or objective of act plays a vital role. Without knowing purpose, without knowing the objectives of act, no one can correctly interpret the act, a word, sentence, line, or provision in act. Electronic Transaction Act. Electronic means, according to the Section 26, Electronic Interpretation Clause of the Act, electronic means in here, information generated, sent, received, or stored by electronic, magnetic, optical, or similar capacities, regardless of the medium. So that information may be in the electronic format, electronic pulse. As a result of the making electronic pulse, you know that 010 language. A magnetic, it may be a pattern of a magnetic, for example, cassette tape or gramophone disc, or optical, fiber optics, or any other type of similar then. And in here you can see a word, similar capacities. This is a very popular term in any ICT law because we are working with working with the technology which has a rapid development. So still we don't know the next level of the technology. So it's always we use a very broad terms in this process. So these type of terms, similar capacities, covers the technology yet to come. And regardless of the medium, still we don't have court interpretation for the last part. So we do have two possible interpretation. It may be the language or the storage medium such as device, right? Regardless, without considering that part, a language, the data message language, and the stored medium, we consider the nature of the data. Actually, the meaning in here, nature of the data. The second part, transaction. Transaction is a popular term in commercial sphere, commercial nature. In singular, ganudenu. Of course, it is a commercial word, but it does not necessarily mean that this act only applicable to commercial field. After being read out the amendment, Electronic Transaction Act Amendment number 25 of 2017, you can identify that as a result of the international influence, as I mentioned in here, this convention, the government has to follow and implement electronic nature, electronic actions, right? They have to adopt electronic.
What is simply called e-governance, right? To introduce
exactly e-governance. We have to adhere to the
where they are supposed to maintain certain documents in e-form, and also the entitlement given to the citizenry to call certain documents in electronic form. That is also an achievement by way of this Amendment Act in 25 of 2017. That's what you're
not
referring
only that, but they specifically mention the court proceedings.
Yes.
Funding proceedings.
Electronic form, filing, proxies, answers, everything can be in electronic form. Yes.
Form. So transaction, even though the term transaction is a popular term in commerce, this act does not necessarily mean that it is applicable only to the commercial nature, right? When and where
but I think it's worthwhile just bringing the exceptions given in section 23 regarding the limitations of applicability, because we have seen in certain occasions, simply purely a testamentary or deed of gift or the last will or something to do with that kind of personal nature. Things where parties were trying to bring these data and electronic documents that has been often rejected. I can remember in one of the cases in a divorce matter, they were trying to get some data using this Electronic Transaction Act without recoursing to the Evidence Special Provisions Act, where that has been denied in the lower court, saying no, because this transaction is entirely a form of a private nature and no elements of commercial transaction or within the ambit of the Amendment Act. Therefore, it is not permitted to bring this data within the contemplation of Electronic Transaction Act in that particular case. So like that, it would be good if you could just enlighten on, yes, it is not purely on electronic transactions, but still there are limitations in getting this applied in certain spheres of law.
Yes, actually, Vardhani, the section 26 purely based on the nature of the document. As far as the document itself speak about the genuinity of the document, we cannot create it in electronic nature, right? For example, the signature on last will. The best possible evidence is the signature. Signature speak about the genuinity and authentication of the document, right? That is the base behind the section 26 of the Electronic Transaction Act, right? There's another reason to introduce this act, that the section 18. Section 18 of the Prevention of the Fraud Ordinance clearly mentioned that document must be reliable to be legally acceptable. So the electronic documents, it actually, we cannot apply this provision exactly on the electronic documents. At the same time, electronic documents produce different version, and no one can identify the original version. For example, if I send a message from my email to you, there are two copies. One copy in my email and the second copy in your email. Still, no one knows which one is the original version, right? So iron out all these type of conundrum or this type of controversials, they introduce Electronic Transaction Act. And again, there are several objectives behind this act. One of them, recognize and facilitate the electronic commerce, already we discussed. And in this act hope to encourage both public and private sectors to promote electronic transaction. In this way, they try to avoiding dispute over the admissibility of e-documents, electronic documents, and other all matters connected with the same. Already we discussed the base of electronic commerce is e-contract. That's why they provide the basic legal nature of electronic contract. So this act intends to recognize and facilitate the formation of electronic contract. It helps to identify the requirements of formation of contract. For example, it explains what is electronic acceptance, what is electronic offer. So not only that, this document provides the legality on the supportive services on the establishment and execution of the Electronic Transaction Act, such as certification authorities, accreditation of certification services. So these are the background information of the introduction of Electronic Transaction Act and the objectives of the Electronic Transaction Act. In here, for your easy reference, I always mark the newest changes made by the Electronic Transaction Amendment Act in 2017 in a separate column in here. So in here, you can see that section 2, as you correctly mentioned in the introductory remark, objectives. So this document facilitates to domestic and international electronic commerce, encourage the use of reliable forms of electronic commerce. C and CA were introduced by the amendment. Amendment address the facilitate electronic filing of any application, petition, plain answer, written submission, or any other document with any codes. So this document encourage the decision-making process, judicial process to apply the electronic nature and to facilitate electronic filing of any form of other government process, e-governance, right? Actually promote efficient delivery of public service by means of reliable form of electronic communication. And again, this document.
Just add a small thing, I think during the hype of Corona pandemic, I think thanks to this law only, we were able to get the electronic platforms activated to give hearings to our matters in court. And also to that effect, there were requirements in amending the rules and all these, which were subsequently done by the Supreme Court. But basic platform was by then already provided under this act. With that privilege only, we were managed to bring that forward. Even at this juncture, we have seen in commercial high court, same in Supreme Court, there are virtual hearings given, getting the evidence virtually from overseas witnesses and all without interfering too much with their personalities and other difficulties, and especially that helps a lot to for case management purposes to avoid unwanted delays and all. So as you correctly, Dr. Abesekar indicated, it's not just streamlining the e-commerce, it helped us to develop into another level in e-governance as well in the country.
Actually, Vardhane, it is not my personal belief that internet is now, it is a fundamental right. It should be a fundamental right. It was a very sophisticated technology and a high level of technology. But now it is a fundamental right. Right to internet or right to have internet is a fundamental right. Without having that type of right, we cannot enjoy these type of provisions in law. It should be a fundamental right of the people in this country. So in this way, this act promote the public confidence on electronic actions, electronic transaction. The general nature of electronic contract is something totally different from the physical versions. Actually, in here, parties do not meet physically. They no need to meet physically. For example, if you buy something from eBay, in man.lk, never you buy, see the seller, Daras, right? There are no physical boundaries. It is very difficult to make physical boundaries as we are working in an electronic platform. No handwritten signatures involved in here, right? And since there's no utmost security, risk factor is high. That law wish to apply and address, right? And jurisdictional issues are a major risk. When we are doing, when we are signing documents in physical form, definitely we have to mention the place. Even in an admission card issued by a examination unit, when you attest the signature, definitely they have to put the place of attestation. It shows the jurisdiction, right? But in here, it is difficult to find the jurisdiction as it is happening in the cloud. No one knows, because in layman mind, cloud is where, right? Where is this cloud, right? So jurisdictional issues are there. And there's no single authority to monitor the whole process of electronic commerce, right? And digital signature are used and electronic records are used as evidence, right? So there are a lot of things. And again, some people argue electronic contract, especially online electronic contract. Online electronic contracts are part of electronic contract, right? There's no basic nature of contract. Later we can discuss. The heart of any type of contract, as I said earlier, it is consists of DIDA, the freedom of contract. In electronic nature, there's no such a freedom. Always the one party, probably the party who has the highest level of bargaining power, he himself decide all the possible terms and conditions of the contract. Nothing left with the other party. So take it or leave it type of contract. So some scholars argued electronic, especially online electronic contracts are not contract per se. So it is another point in courts, right? At the higher level, right? And the subject matter includes in electronic contract, physical goods, digital goods, digitized products, service like electronic banking, financial advisors, Uber Eats, so on, right? So that is the nature of e-contracts. Formation of electronic contracts based on this Act, Section 11. So in the context of contract formation, unless otherwise agreed by the parties. As I earlier mentioned, this is the freedom. Still, parties can decide the nature of their contract, even though we do have a Electronic Transaction Act, right? That's why you might have seen this part in practice. The financial institution, when they are doing every initial step of their hire purchase contract, finally they ask people to come into the head office or the place to put their signatures, because it is very crucial point and very vulnerable thing and vulnerable to misuse thing. So the parties finally can decide, no, you have to come, right? Because they know the final results. The final they can say, no, it is not my signature. Someone has put and take a picture and send it to you. It is not my signature. So still, even though they have used different type of electronic nature in the process of making their contract, they can decide the nature of the contract. That's why they made, unless otherwise agreed by the parties. They might have a different agreement. If they don't have such type of agreement, the offer and acceptance of the offer may be expressed in electronic form. Actually, the newest version and the newest amendment to the Act in 2017 inserted 11A part, right? According to that part, it clearly give an indication on offer, right? Actually, it shows the difference between a normal advertisement and advertisement on web. Normally, we know that all advertisements are invitation to treat, and they are not offer. Advertisements are, according to the common law rule, advertisement are considered and treated as invitation to treat. But when advertisement in online mode, advertisement on web, our Act, thanks to the inserted new part 11A, there are two different concerns. In here, a proposal to conclude a contract made through one or more electronic communication which is not addressed to one or more specific parties. Then it is invitation to offer, invitation to treat. If they address a particular person through online advertisement, it is an offer. That is the meaning of 11A in here. Later we can discuss it, right? So normally you know that, as I said earlier, advertisements on any place, it is an invitation to treat under the common law principle, right? Advertisement on website, under the light of the 11A, it based on the addressee. If the person who put the proposal on website and he addressed a specific person or group through his advertisement on website, it is not an invitation to trade. It is an offer. If it is not a such type of advertisement, it is an open advertisement without mentioning any addressee, but say it is an invitation to trade. Actually, there is a technical reason, ICT technical reason. If that item is available for large crowd of people, or it is difficult to mention the number of people based on the technology. For example, Kaspersky. So Kaspersky advertisement address a number of people now. Any person who wish to pay the payment, they can download the software. So no one can see, no one can imagine the number of software available in the Kaspersky website. It is a technical nature, right? So then the provider, proposer, the Kaspersky owner, he can decide first come, first serve base. He can go for the first come, first serve basis or any other basis. Because of that reason, it considered as an invitation to treat, right? If the person,
So if I
put
it in a simplified manner just for the benefit of the audience, and we are also almost reaching the deadline, the timing as well. So we might have to expedite the explanation as well, Dr. Basically, I'm afraid I know you are engulfed with explaining it in very extensive manner, but it is unfortunate we have to confine ourselves into a particular timeline as well. So if I put it in a simplest version, like using the same example, let's say if something appeared there by an advertisement by the Kaspersky and we made an offer, still the Kaspersky have the liberty of not entering into a contract with us simply because we have made an offer, because or we have shown some interest to purchase such product. Still they can reject that because it's just an invitation to offer and it's not within the contemplation of an offer as stipulated in section 11 we discussed earlier. That's the difference that we are trying to make it here.
Yes. Yeah.
Right. So if we are skipping, if we are just discussing or coupling this with the e-signature, if somebody want to form a formal contract within the contemplation of this act, does it necessarily require to be endorsed with a e-signature? If you can explain a bit on the electronic signature in terms of section 7 of the act, Dr. Visekara?
Yeah, actually the section 7 in here, it confirm the applicability of e-signature. E-signature is a part of written, actually signature is a part of written documents, right? It is an essential part of written. In electronic version, e-signature. So section 7 gives the legal recognition on electronic signature, right? However, there's a very interesting point. The original act introduced a different version of a different interpretation on electronic signature, which is a very broad interpretation, according to my understanding. The newest act, the amendment, give a not very but considerably narrow interpretation on electronic signature. The interesting part in both of them is they identify two parts in signature: appearance as well as the intention of the party. See the wordings of both of them. In here, I blur the earliest version, right, for your easy reference. This is the newest one. So that signature, electronic signature, right, may be used to identify the signatory in relation of the electronic document, and may be used to indicate the signator's intention. You know, the interesting point in Sri Lanka, still we don't have any interpretation on manuscript signature. I mean, the legal instrument, the statutory instrument are silent on manuscript signature, handwritten signature. Only place I found that Miyappan versus Manchanayaka case. It explained the handwritten signature. And in here, another interesting point. Some people
and
are,
also, if I'm right there, the section 18 of the Preventions Frauds Ordinance, as well as the section 17 of the registration of the documents, which refers the requirement of the document has to be in written form, plus the signature of the parties has to be there to get the legal effect. For that,
but none of them interpret the nature of the signature.
Yes, that has not been interpreted.
Yeah,
So
this is the only
basically,
place. Yeah, this is the only place which explain the meaning of signature, electronic signature.
basically, by doing this, the traditional requirement of e-signature has been now dispensed with under this section 26 interpretation, right? It could be anything within the contemplation of the electronic form or a data message or anything, right?
Yeah, yeah. Actually, still it is not the case given. The case interpretation is also not a sufficient one. It is very simple.
There's a recent judgment, not really recent, like years ago.
No, it is 1962.
Yeah, subsequent to that, in 2018, the Commissioner General of Inland Revenue was a Janashakti Insurance, where the auto-generated TIN certificate has been questioned about the admissibility. Where court has clearly held, although it does not contain any signature, that can be considered as a valid document under the Electronic Transactions Act. That is, and again,
actually,
about
there are a lot of places that they discuss the requirement of signature.
Yeah.
But none of them discuss the nature or interpretation of manuscript signature. That is my point, right? So
basically, what
electronic signature is
constitutes
the
a
place.
signature within this section 26 that has not been dealt detail in any legal proceedings, what you're saying. Yes, I agree with that. Yes.
Yeah, right. Actually, quickly, I want to come into in here, the email, the postal rule, acceptance, right? It is also a very interesting point in Electronic Transaction Act. So, you know that the postal rule is a rule available in common law, right? According to the postal rule, at the time when they post the letter, drop into the mailbox or hand it over to the officer at the post office, that is the place they conclude and fulfill the requirement of acceptance. But we cannot apply the same thing to the email, right? So we have to check the person who dispatch it and whether he has whether addressee has provided his own email address. Actually, they don't have the term acceptance in here. This act helps to identify the time of dispatch and time of receipt. If you are the person who control the origination of the message, time of dispatch is the time you click the send button. If you are not the person, or if you are the person work on behalf of another one, the time of the dispatch is the time the other party receive the message. On the other side of the coin, the receipt, the time of receipt of data message based on the addressee's ownership of the email. Under the section 14, subsection 2, entirely introduced by the Amendment Act, the second part of the 14 subsection 2A, the addressee has designated an electronic address. If it is the case, the time of receipt occurs at the time when that said message becomes capable of being retrieved by the addressee. For example, in my visa application to UK, in my application, I mentioned my own email address. So last night, 8 o'clock, I received an email from British High Commission. The time of receipt of that mail is last night, 8 o'clock, because I mentioned my own email address. If an addressee mention another person email address in the process, for example, my mother is going to apply for her Indian visa application as a part of her pilgrim Vandana Gamana. So she is going to mention, she already mentioned her in her application my email address instead of her email, because she doesn't have email address. And last night, 8 o'clock, there was a message from Indian High Commission regarding her application. Today morning, I informed her, Amme, there was a message for you. Then the time of retrieve of message is not the last night, the time she got to know the message was there, the today morning. That is the difference in here. See the second part of here. If the addressee has no designated an electronic address, has indicated another electronic address, the time of receipt occurs at the time when becomes capable of being retrieved by the addressee at the electronic address, and the addressee becomes aware. So the second case, they consider the aware, right? So they consider the nature, the ownership of the address. If it is your own email address, the technology considered at any time you can access it to the address. If it is not your address, at any time you cannot address. So actually we can apply this situation to the official email address. After 5 o'clock, so it is not the office hours. So with that point, we can argue no one can access it to, unless otherwise they do have a special authorities, right? And it is very high point in Friday evening, Friday 5 o'clock, they receive the message, but officially they open it up in Monday morning, 8 o'clock, 8:30. So in between that time, whether the other party can take a decision or not, right? The same situations in postal rule, right? So in acceptance, we consider the ownership of the, actually the address, electronic address. Electronic address may be an email or any other type of thing, right? Actually, this act, the newest version, give a interpretation for the electronic address under the interpretation clause section 6. So it may be electronic mailbox, right? Or telecopy device, a designated portion or location in the information system, a specific place in an information system, or any other type of thing, such as WhatsApp account, right? So not only the electronic, the email or any other type of thing, right? So these are the things with the postal rule, especially in the light of acceptance. And jurisdiction, another crucial point. So always the parties can decide the jurisdiction. You might have seen, as lawyers, we know that there's a special provision in every contract, the jurisdiction, right? To kind of jurisdictional issues. So still parties can decide their jurisdiction despite the electronic nature of the contract. If they don't have such type of thing, the law decide the jurisdiction based on the section 13, subsection 3. So dispatch, the place of dispatch and place of receive. Based on that, they decide the jurisdiction. Basically, they do have two jurisdictions, right?
So if
And
I put it in a person, sorry for disturbing. So let's say the sellers they are in England, but we made an offer here in Sri Lanka. And if it is accepted, so we here as in Sri Lankan person who accepted it gets the jurisdiction to sue against that person there in UK in the simplest version.
Actually, Vardhani, then we have to get the support from the applicable law clause as well. Right? Normally in contract, we decide the applicable law, no? Then we have to read out the jurisdiction under the light of the applicable law, right? As you correctly mentioned, if they don't have clear out the application of the law, of course, they do have two totally different jurisdictions, right? Actually, we have to read out this jurisdiction clause under the light of the
jurisdiction can run from England to Sri Lanka. If they want, they can claim they have the jurisdiction they are in UK, whereas the party from Sri Lanka can claim we have the jurisdiction to hear and determine the matter under the in Sri Lanka.
Yes. If they consider the Sri Lankan law under the application of law, but they did not decide the jurisdiction, the place of the get into the contract, then probably the place is in Sri Lanka because of the influence of the jurisdiction, the application of the law, right?
But we call the governing law in contracts, we generally put a clause on the governing law.
Governing law.
This would apply in determining the issues, disputes, everything. So unless otherwise determined by a specific clause, then the governing law, we can go by section 14.3 of the Electronic Transaction Act in deciding which court gets or which country gets the jurisdiction to hear and determine such case.
Actually, then it is a very actually complicated situation, because then we have to decide whether this act is also, whether it is also applicable to the situation, right? So when we come to the online contract, there are different type of contracts. So I'm not going to explain all of them, right? So basically there are 4 different type of online contracts. As I said earlier, all online contracts are electronic contract, but all electronic contracts are not online. Online means when the system connect to the communication channel. And as I said earlier, the free consent is the heart of contract, meeting of mind. Without having meeting of mind, normally the contract law does not believe that there is a contract. But unfortunately, in electronic nature, most of contracts are without having meeting of minds. Those contract name as standard form contracts or addition form contract. As I said earlier, the take it or leave it type of contract, because the party who has the highest level of bargaining power, he himself decide all the terms and conditions of the contract. Nothing left with the other party. The other party cannot, nothing in there. For example, when we are making a Facebook account, it is a contract. We cannot change even a single term or a single dot in the contract given by Mark Zuckerberg and the team. Only thing available to us, take it or leave it. That's why they name it the take it or leave it type of contract. There are several take it or leave it type of contract. For example, string wrap contract, click wrap contract. Actually, in these contract, first the customer has to click the accept button in order to see the terms of the contract, right? So in these type of contracts, law believes that there are no proper contract or common law type of contract. So it is an interesting point, but still low.
At the same time, I guess that was so much of critique, especially in the Sri Lankan context, about the customer care or customer rights and the data protection privileges not being given, or there's no adequate legal measures and the safeguards in Sri Lankan law to protect the rights of the customers in the digital platforms. Isn't that something we should be conscious about?
Actually, as a lawyers, we first consider the basic of the point. No, in order to everything, we have to check the legal validity of the point. If there's no contract, no one can build up their argument based on the contract law, right? So actually, that is the problem with this type of online contract. actually there's no such a contractual mind, the free minds of the parties. This is the point we discussed. So some documents are excluded from Electronic Transaction Act. It means these documents cannot be made in electronic version. So no one can produce the.
Yeah, it is because, sorry for interruption. I think since we are also running out of time, I might have to interrupt you on and off, Dr. Besekar. I know it is very interesting to follow, but we have to stick to the timeline as well. It's because of, as we discussed about the applicability of prevention of fraud ordinance and the document registration requirements, which entails they are cutting across these last phase gifts, transactions, and all these things. That might be one reason that they want to keep the entire realm of this that area away from the Electronic Transactions Act.
Yes.
And also, if you have to discuss a little bit on the rule of admissibility of electronic evidence.
Exactly. Yes.
This act.
The rules governing evidence under the section 21. Yeah. Actually, this instrument, this Electronic Transaction Act, address the evidence in electronic nature. Where it is applicable, no one can apply the Evidence Special Provision Act number 14 of 1995. That is the simple explanation. Apart from that, if it is available, they can produce a person with the electronic evidence. However, it does not necessarily mean that if there's no a person, there's no reliability on the evidence. For example, if it is a bank statement, apart from the bank statement, production of bank statement, that party can produce the authoritative officer as a evidence. If that person who is dead, the authoritative person is dead, or is outside of the Sri Lanka and where reasonable steps have been taken by the police to find the person, or who does not wish to give oral evidence through fear, or is prevent from such type of giving evidence in courts, then the document itself, it is evidence.
Right? Yeah, basically it says the genuineness of the signature as well as the truth of the information contained in such electronic document presumed to be as genuine unless otherwise proved by the opposing side. So that gives a very strong position in law. If somebody to fight a case in court, if something produced in electronic form within the requirements of the act, I think we don't need to bring any further evidence to establish either genuineness of the electronic signature as well as the content of the information contained in such document. I think this is very crucial section in law for the proper to expedite the matters.
Actually, Vardhani, it would be better identified that the contents of the documents and signature of the document plays two roles in here.
Yeah.
Right? So we have to check it in two different points: contents of the document and the name of the signature of the document. Actually, in these cases, the foreign cases, they mentioned that type name on a telex was a signature in England. In this case, 2003, Good Challengers Navigates SA case, they accepted that name on a telex message confirmed the contents of the message. So they consider the name, type name on a telex message as a signature, and it signatures to the content. But in the same courts, same jurisdiction, Nilesh case, they did not accept the same thing on the emails, right? So the contents of the message and in electronic nature, the signature on the same are two different parts, right? So these are the things with the application, the admissibility of the electronic evidence. This document address the electronic evidence where it is applicable. We are not actually, there's no point to apply the Evidence Special Provision Act. And finally, I would like to draw your attention on the interpretation of the computer given by the interpretation clause of this act. It is another funny thing. According to the interpretation given by this act, the computer means an electronic or similar device having information processing capabilities. As a layman mind, we know that all devices which have information processing capabilities, it is not a computer. According to this given interpretation, calculator is also a computer. Washing machine is automated washing machine is also a computer because they have information processing capabilities. So actually all these argument based on the computer nature, right? But computer, according to the meaning of the computer, is a very complicated things under the Electronic Transaction Act. So these are the basic things with the Electronic Transaction and applicability of the Electronic Transaction Act in Sri Lanka.
Just to add a small bit, I think we have skipped when you're discussing the section 21. The following section, the section 21, expressly excludes the applicability of Evidence Special Provisions Act.
Yes,
if it
yes.
comes within this realm of electronic transaction, even in some recent judgments, unreported, I found some ITN versus Godakam Herbers Private Limited, where this running account maintained in electronic form has been accepted under section 21, and applying section 22, they recognize you don't need to recourse to the provisions under the Evidence Special Provisions Act because it governs and it comes under the Electronic Transactions Act.
Yes.
Yeah, so that is also something we'll have to keep that in mind, and especially with the new amendment, the section 20, Act number 29 of 2022, the evidence, the Civil Procedure Code Amendment Act provides provision for this pre-trial conferencing, also deals with the admissibility of electronic documents in evidence form, where it clearly says what it is stated in the Electronic Evidence Act or the Electronic Transaction Act does not apply in that context. It generally deals with any electronic document that can be presented or the admissibility of such electronic document during a court proceedings in the trial procedure. The procedure has been laid out. So I think in a way, it's kind of a progressive movement because we know in the practical context, it is very tedious process that we'll have to go through in the Evidence Special Provisions Act. Now under this Act number 29 of 2022, the CPC special provisions gives us a very concise or very specific process, including timeline to adopt and admit electronic documents as in evidence. But here, I think we are talking about entirely a different segment where how these provisions would apply in a transaction or something applicable within the context of electronic transactions. Because otherwise, if somebody wants to look at that section, that is section 79C of this Amendment Act number 29 of 2023 Civil Procedure Code, clearly distinguish this application of Evidence Special Provisions Act and also the Electronic Transactions Act from the CPC New Amendment Act, just to enlighten the audience for their benefit, I guess. I just
very correct, Vardhani. Actually, in 1995, the Sri Lankan governor, Sri Lankan legal fraternity, opened up the space for electronic evidence. So it does not necessarily address all the aspects of electronic evidence. Then now, time to time, we have to change it. That's why we are taking such type of different steps in the process of applicability of the discussion of the applicability of or admissibility of the electronic evidence. That is the reason.
And I would like to invite our participants, the members of our fraternity, to raise their voice if there's any clarity or any questions to be posed. I'm sure Dr. Abesekara is well prepared to answer all your concerns and give further explanations. It is over to you, my dear participants. If there's anything, either you can inbox or you can always raise your hand. They are in this platform. If there are no any questions, just a small thing. What would you think about the loopholes that needs to be immediately addressed in this context of Electronic Transactions Act? Just as a closing remark for this session, I'm posing this question to you, Dr. Abesekara.
Actually, as you all are well aware, we are working with highly sophisticated technology which has a rapid development. So it is very difficult to introduce a very concrete law or precise law. Actually, electronic, the term, address the electronic nature which has a rapid development. So no one in this world can make a precise law. So always law work behind the technology, right? So always it is a kind of roadrunner race, right? The police, the law and lawmakers all are well behind the technology, right? And technology is very advanced in this process. So there, in this sense, we could identify a lot of but a considerable number of loopholes in this law. One of them, it is not correctly addressed the real nature of the contract, such as the standard form or addition form of contract. And still there are some mismatches with the real technological terms, the interpretation of terms, interpretation clause. As I said earlier, the basic notion of this platform is computer, but still the computer, it is not a same, it is not the wrong in here. This is the same interpretation in Computer Crime Act also, right? So they do not correctly identify the what the computer is, right? It provides a very broad, unnecessarily broad computer. Finally, create some devices which are not computers and consider it as a computer. And again, evidence rule. Actually, that evidence which are considered and accepted through the Electronic Transaction Act do not correctly address the basic rules of evidence. It is a point, right? Normally, we accept in evidence the very genuine, very authenticated, and the first copy. But the term first copy is an immaterial thing in electronic nature, because the technology at once create lot of copies. So no one can identify which one is the original copy. So these are the basic problem with this act. However, we know that the reason behind the problem, because we are dealing with the highly sophisticated technology which has a rapid development.
As it is an evolving area, as well as we are living the global village. If we are to confine with our domestic sphere, again, that will be create a havoc in applying in the international commerce and international legal arena as well. So they might have to keep certain terms broad as much as they can to accommodate the different requirements in different jurisdictions as well, I guess. So yes. I must take this opportunity to thank Dr. Tusita Abesekara. So sharing his valuable thoughts, knowledge, and expertise. He's one of the expertise in this field of IT. And also it is very important what he has shared now, the legal insights, especially the conceptual background and theories and principles behind these particular sections of Electronic Transaction Act, which gives them a good understanding of the particular wording used in this act. So I think that was very insightful and also very useful, Dr. Abesekara. I thank you on behalf of the Bar Association once again, and we'll meet you again on another series, another session online or otherwise. And also I thank you all the participants taking your time to join with us, and I hope this find interesting and some knowledge can be utilized in your practice or in your professional career. And finally, I would like to thank the Bar Association of Sri Lanka providing this opportunity to share this knowledge among our members in this webinar platform. So we'll see you again on another webinar discussion on a timely topic. Thank you. Stay tuned. Good night.
Okay. Thank you very much.
Dr. Tusita, there's one question they are referring to the implications of getting AI into this issue, and that participant is also there. If you don't mind, if you have a minute, if you could just inbox him an answer.